84 Chapter via Appellate Tribunal Establishment of Appellate Tribunal, 53A. 1. The National Company Law Appellate Tribunal constituted under Section 410 of the Companies Act, 2013 shall, on and from the commencement of Part 14 of Chapter 6 of the Finance Act, 2017, be the Appellate Tribunal for the purpose of this Act, and the said Appellate Tribunal shall a. to hear and dispose of appeals against any direction issued or decision made or order passed by the Commission under subsections 2 and 6 of Section 26, Section 27, Section 28, Section 31, Section 32, Section 33, Section 38, Section 39, Section 43, Section 43A, Section 44, Section 45 or Section 46 of the Act, b. to adjudicate on claim for compensation that may arise from the findings of the Commission or the orders of the Appellate Tribunal in an appeal against any finding of the Commission or under Section 42A or under subsection 2 of Section 53Q of this Act, and pass orders for the recovery of compensation under Section 53N of this Act. Appeal to Appellate Tribunal 53B. 1. The central government or the state government or a local authority or enterprise or any person, aggrieved by any direction, decision or order referred to in Clause A of Section 53A may prefer an appeal to the Appellate Tribunal. 2. Every appeal under subsection 1 shall be filed within a period of 60 days from the date on which a copy of the direction or decision or order made by the Commission is received by the central government or the state government or a local authority or enterprise or any person referred to in that subsection, and it shall be in such form and be accompanied by such fee as may be prescribed, provided that the Appellate Tribunal may entertain an appeal after the expiry of the said period of 60 days if it is satisfied that there was sufficient cause for not filing it within that period. 3. On receipt of an appeal under subsection 1, the Appellate Tribunal may, after giving the parties to the appeal an opportunity of being heard, pass such orders thereon as it thinks fit, confirming, modifying or setting aside the direction, decision or order appealed against. 84 inches Chapter via, inserted by Competition Amendment Act, 2007 45. 4. The Appellate Tribunal shall send a copy of every order made by it to the Commission and the parties to the appeal. 5. The appeal filed before the Appellate Tribunal under subsection 1 shall be dealt with by it as expeditiously as possible, and endeavors shall be made by it to dispose of the appeal within 6 months from the date of receipt of the appeal. Omitted by the Finance Act, 2017, W. E. F. the 26th of May 2017, awarding compensation. 53N. 1. Without prejudice to any other provisions contained in this Act, the central government or a state government or a local authority or any enterprise or any person may make an application to the Appellate Tribunal to adjudicate on claim for compensation that may arise from the findings of the Commission or the orders of the Appellate Tribunal in an appeal against any findings of the Commission or under Section 42A or under subsection 2 of Section 53Q of the Act, and to pass an order for the recovery of compensation from any enterprise for any loss or damage shown to have been suffered by the central government or a state government or a local authority or any enterprise or any person as a result of any contravention of the provisions of Chapter 2, having been committed by enterprise. 2. Every application made under subsection 1 shall be accompanied by the findings of the Commission, if any, and also be accompanied with such fees as may be prescribed. 3. The Appellate Tribunal may, after an inquiry made into the allegations mentioned in the application made under subsection 1, pass an order directing the enterprise to make payment to the applicant of the amount determined by it as realizable from the enterprise as compensation for the loss or damage caused to the applicant as a result of any contravention of the provisions of Chapter 2 having been committed by such enterprise, provided that the Appellate Tribunal may obtain the recommendations of the Commission before passing an order of compensation. 4. Where any loss or damage referred to in subsection 1 is caused to numerous persons having the same interest, one or more of such persons may, with the permission of the Appellate Tribunal, make an application under that subsection for and on behalf of, or for the benefit of, the persons so interested, and thereupon, the provisions of Rule 8 of Order 1 of the First Schedule to the Code of Civil Procedure, 19085 of 1908, shall apply subject to the modification that every reference therein to a suit or decree shall be construed as a reference to the application before the Appellate Tribunal and the order of the Appellate Tribunal thereon. Explanation. For the removal of doubts, it is hereby declared that a. An application may be made for compensation before the Appellate 46. 47. Tribunal only after either the Commission or the Appellate Tribunal on appeal under Clause A of subsection 1 of Section 53A of the Act has determined in a proceeding before it that violation of the provisions of the Act has taken place, or if provisions of Section 42A or subsection 2 of Section 53Q of the Act are retracted. B. Inquiry to be conducted under subsection 3 shall be for the purpose of determining the eligibility and quantum of compensation due to a person applying for the same, and not for examining afresh the findings of the Commission or the Appellate Tribunal on whether any violation of the Act has taken place. Procedures and Powers of Appellate Tribunal 53.0. 1. The Appellate Tribunal shall not be bound by the procedure laid down in the Code of Civil Procedure, 1908-5 of 1908, but shall be guided by the principles of natural justice and, subject to the other provisions of this Act and of any rules made by the central government, the Appellate Tribunal shall have power to regulate its own procedure including the places at which they shall have their sittings. 2. The Appellate Tribunal shall have, for the purposes of discharging its functions under this Act, the same powers as are vested in a civil court under the Code of Civil Procedure, 1908-5 of 1908 while trying a suit in respect of the following matters, namely, a. Summoning and enforcing the attendance of any person and examining him on oath, b. Requiring the discovery and production of documents, c. Receiving evidence on affidavit, d. Subject to the provisions of Sections 123 and 124 of the Indian Evidence Act, 1872, 1 of 1872, requisitioning any public record or document or copy of such record or document from any office, e. Issuing commissions for the examination of witnesses or documents, f. Reviewing its decisions, g. Dismissing a representation for default or deciding it ex parte, h. Setting aside any order of dismissal of any representation for default or any order passed by it ex parte, i. Any other matter which may be prescribed. 3. Every proceedings before the Appellate Tribunal shall be deemed to be judicial proceedings within the meaning of Sections 193 and 228, and for the purposes of Section 196, of the Indian Penal Code 45 of 1860, and the Appellate Tribunal shall be deemed to be a civil court for the purposes of Section 195 and Chapter 26 of the Code or Criminal Procedure, 1973 2 of 1974. Execution of Orders of Appellate Tribunal 53p. 1. Every order made by the Appellate Tribunal shall be enforced by it in the same manner as if it were a decree made by a court in a suit pending therein, and it shall be lawful for the Appellate Tribunal to send, in case of its inability to execute such order, to the court within the local limits of whose jurisdiction, a. In the case of an order against a company, the registered office of the company is situated, or b. In the case of an order against any other person, place where the person concerned voluntarily resides or carries on business or personally works for gain, is situated. 2. Notwithstanding anything contained in subsection 1, the Appellate Tribunal may transmit any order made by it to a civil court having local jurisdiction, and such civil court shall execute the order as if it were a decree made by that court. Contravention of Orders of Appellate Tribunal 53q. 1. Without prejudice to the provisions of this Act, if any person contravenes, without any reasonable ground, any order of the Appellate Tribunal, he shall be liable for a penalty of not exceeding Rs1 crore or imprisonment for a term up to 3 years or with both as the Chief Metropolitan Magistrate, Delhi may deem fit, provided that the Chief Metropolitan Magistrate, Delhi shall not take cognizance of any offence punishable under this subsection, save on a complaint made by an officer authorized by the Appellate Tribunal. 2. Without prejudice to the provisions of this Act, any person may make an application to the Appellate Tribunal for an order for the recovery of compensation from any enterprise for any loss or damage shown to have been suffered by such person as a result of the said enterprise contravening, without any reasonable ground, any order of the Appellate Tribunal or delaying in carrying out such orders of the Appellate Tribunal. 53r. Omitted by the Finance Act, 2017, W. E. F. The 26th of May 2017, Right to Legal Representation 53s. 1. A person preferring an appeal to the Appellate Tribunal may either appear in person or authorize one or more chartered accountants or company secretaries or cost accountants or legal practitioners or any of its officers to present his or its case before the Appellate Tribunal. 2. The central government or a state government or a local authority or any enterprise preferring an appeal to the Appellate Tribunal may authorize one or more chartered accountants or company secretaries or cost 48. Accountants or legal practitioners or any of its officers to act as presenting officers, and every person so authorized may present the case with respect to any appeal before the Appellate Tribunal. 3. The Commission may authorize one or more chartered accountants or company secretaries or cost accountants or legal practitioners or any of its officers to act as presenting officers, and every person so authorized may present the case with respect to any appeal before the Appellate Tribunal. Explanation. The expressions, chartered accountant, or company secretary, or cost accountant, or legal practitioner, shall have the meanings respectively assigned to them in the explanation to Section 35. Appeal to Supreme Court 53t. The central government or any state government or the commission or any statutory authority or any local authority or any enterprise or any person aggrieved by any decision or order of the appellate tribunal may file an appeal to the Supreme Court within 60 days from the date of communication of the decision or order of the appellate tribunal to them, provided that the Supreme Court may, if it is satisfied that the applicant was prevented by sufficient cause from filing the appeal within the said period, allow it to be filed after the expiry of the said period of 60 days. Power to punish for contempt 53u. The appellate tribunal shall have, and exercise, the same jurisdiction, powers and authority in respect of contempt of itself as a high court has and may exercise and, for this purpose, the provisions of the Contempt of Courts Act, 1971, 70 of 1971 shall have effect subject to modifications that a. The reference therein to a high court shall be construed as including a reference to the appellate tribunal. B. The references to the Advocate General in Section 15 of the said Act shall be construed as a reference to such law officer as the central government may, by notification, specify in this behalf. 49.